Welcome. This is Dr. David D. Schein and another exciting edition of Business Law 101. This is very special because we don't do a lot of interviews, but we have a great guest today to talk about the Corporate Transparency Act. CTA was passed by Congress already several years ago, 2021, to be effective this year. It is a very sweeping piece of legislation. And today we have our special guest, to talk about CTA law, Scott Dondershine. He is a partner with the Reston Law Group in Reston, Virginia, where he focuses on corporate and tax law. Thank you, Scott, for agreeing to help our audience with this broad new law.
Thank you, and I'm glad to participate. It's an important piece of legislation.
Yeah, let's dig into the details. So what business entities have to comply? Because I know that some are exempt.
Yeah, so the act applies, the technical term here is reporting companies, but a lot are exempt, as you noted. There's actually 23 exemptions. So the first question, though, is, before we get into the exemptions, is, are you a reporting company? So a reporting company is any entity created by filing articles of organization or incorporation with a particular state or Indian tribe. For example, in Delaware, you might file articles of organization. Foreign entities may also be subject to the act, though, if they're registered to do business in the U.S. state. So if you have a company located overseas, but they registered themselves in the United States to service the United States, then they also have to comply.
Well, we don't want to go through 23 exemptions, but one or a couple quick examples of exempt companies.
Perfect. Yes, I didn't think you wanted to, but there's a good reason the act is organized this way, with various exemptions, and I'm just going to hit two, because in broad strokes, a lot of the exemptions are based upon the purpose of the act, which is to police money laundering. And so entities that are large or that are already being monitored by the feds present less of a risk for being used by money laundering. For example, banks, credit unions, tax-exempt entities, and publicly traded entities, they already receive sufficient scrutiny. They're already registered with various government agencies, and so they are going to be exempt. But the highest scrutinized categories is likely to be large operating companies. Large operating companies, and they're not very large, by the way. They're those companies having more than 20 employees, a physical presence in the U.S., and more than $5 million in sales or gross receipts. That's why it's a low threshold. They call it large operating companies, but it's a pretty low threshold to trigger that.
And those will be exempt.
Correct.
Because they're already visible enough is the concept.
Correct.
Okay. So what do you need to do to comply with the CTA?
Well, there's two main requirements. Basically, if you're a reporting company, then you have to file information about the company applicant. And that's basically the person who formed the entity. So if you go to a law firm, it could be a paralegal, or it could be a first-year associate, but then also the attorney that supervised that person. Or if you use you do it yourself, then you're the company applicant. Or if you hire a registered agent company to form it, then information about that registered agent company, that's the company applicant. And for any company applicant, you have to submit information about their name, their date of birth, their address, and a unique identification document like a passport or a driver's license. Now, that's the company applicant. The biggest task here is the heaviest lift is going to be to file information about each beneficial owner of the company, the reporting company. So who is a beneficial owner? A beneficial owner is any individual who directly or indirectly exercises substantial control over the reporting company. For example, a senior officer, a trustee of a trust that itself is the owner. Those types of folks are going to be captured because they exercise substantial control. And then you have to look at the actual owners themselves. So anybody that owns or controls at least 25% of the reporting company also must be reported. So it's going to be somewhat easy to figure out who your actual owners are, but the more intricate part of it is figuring out, well, who exercises substantial control? Who are the senior officers? What does that term senior officer mean? And some companies have nestled companies where they may be owned by a holding company, indirectly owned by another company. So basically, you're drilling down to the individual who owns and controls that entire piece of corporate subsidiaries. And in some cases, again, it's even those who don't even own the entity because they exercise substantial control.
Now, understand that there's a set of deadlines here. So there's deadlines here in 2024 for which companies, and then what about companies that are created after this?
Yes, that's exactly correct. For entities formed prior to 2024, a reporting company must file by the end of 2024. So they give you a whole year if you've been formed in 2023 or before. An important set of information here is that if you are in that subset of companies that have already been formed prior to 2024, you don't have to report information about the company applicant. For entities formed in 2024, you have 90 days to report about the beneficial owners and the company applicants. And for entities formed after 2024, you have 30 days because the normal time period is 30 days.
Okay. So there's a phase-in period basically, and then at basically 2025, it's going to be 30 days. Now, is this going to be annual? Are you going to have to file every year?
No, you file once, but if there are any changes,
yes,
to the information, then you have 30 days to report that change. And so that brings up something that I think is important for everybody to understand, and that is that you may yourself get a FinCEN identifying number, and then you just have to report that number. And the reason why that's important is, let's say you're a company and you have 15 different owners, and you don't want to have to report every time somebody moves from, California to Florida or New York to Florida. You essentially would just report that person's FinCEN identifying number, and then that person, not the company, that person has a responsibility to change its information to update because it is the person that filed for the identifying number. And so then the onus is on them to update their own information. So so it depends upon how it's filed, but basically within 30 days of any change, there has to be an update either by the company or by the beneficial owner, him or herself.
What's the penalty? What happens if you just say, it's just more red tape, I don't need to do it?
So for any willful failure, it's $500 every day, up to $10,000. So if you have to file, FinCEN goes after you, they prove that it's a willful violation, then you're on the hook potentially for $500 a day, up to $10,000. And in the most egregious situations, imprisonment for up to 2 years is filed. But I think it's important to put all this in context. The purpose of the act is to police money laundering. That's what they're going after. So if it's a small company, yes, they may have seen some blogs about the CTA, but they don't really understand it. I suspect FinCEN's not going to go after them, at least for the first few years of the act. But if they're actually a bad actor and they are laundering money, or there are other issues going on, and they have notice of it and so forth, then I think those are the people that are going to get fined. But who knows? Because this is all new, and we're going to learn as it goes along.
Well, I am personally increasingly concerned about data security. You know, I found out one of my email addresses has been found on the dark web. Nothing further other than, hey, we found it on the dark web. But what about the security of this information? I mean, we've seen so many major data breaches, and I'm specific about this because they're asking for the birth date of the beneficial owner. I happen to own a small corporation. I am the sole owner. I would be the sole reporter. And I guard my birth date since I know it is one of the things that people who steal identities use.
That's a great question. And it's a valid concern. Because it is going to be kept in a government database, but there are hacks, as everybody knows.
Yes.
Countries hack, individuals hack, and there is information as a result on the dark web. So your concern is duly noted. So first of all, the database in theory is only accessible to state, local, and tribal law enforcement agencies with court authorization, foreign law enforcement agencies. So that may concern. So it's not just people in the United States. It may be a law enforcement agency located overseas that has some sort of connection or authorization from the US. And then also financial institutions that meet customer due diligence requirements and regulatory supervising requirements. So they will have access to the database. But again, the big concern here is if the database is hacked, or if somebody gets access, legitimate access to it, but then they themselves are hacked. It is a problem. Unfortunately, in this day and age, it's a problem we have to understand and live with to some extent. And you're doing the right step by trying to minimize it. And one piece of information that I would like to go back to, which I think will help, is if people report their FinCEN number. So let's say that you have 5 different companies, and for each company you put your date of birth in 5 times. So that's what you would do if you didn't get a FinCEN identification number. But if you got a FinCEN identification number, then by getting that number, you would put your date of birth in that time, but then you would just report your FinCEN number. So I think that's a benefit of going down that approach.
Okay, just to clarify, so you go in and you would record, say, company 1, and then company 1 would get a FinCEN number, and then you could use that FinCEN number to record company 2, 3, 4.
No, I mean, so for example, company applicant, an individual right now can go and get their FinCEN number.
And where do you do that?
If you go to fincen.gov,
okay,
you can navigate to a link to do that. And then you would then get a FinCEN number. You would upload some information, including your date of birth. You would then get a FinCEN number. And then each time your FinCEN number is needed as a company applicant, you would report that FinCEN number, not your personal information, because your personal information is already in the database.
Gotcha. That makes sense. So let's be clear for our listeners, it's FINCEN.gov.
Correct.
Okay,
Correct.
yeah, because the letters, the way we're saying it, because we're comfortable with it, because you and I both seen it written, a person perhaps listening to our audio cast may not pick that up.
That's correct. Yeah, and Dave, one more thing. So I had said that the FinCEN process applies to company applicants. I believe it also applies to beneficial owners. So again, if you're the owner of 10 different companies, you can get your FinCEN number as a beneficial owner and then just give that on behalf of the companies.
Very good. And I've actually realized that I actually have an interest in an LLC and that I do not control. but that if they felt that they needed to have me listed, then by listing the FinCEN myself, then I could avoid providing that data further down the daisy chain.
Correct.
Makes
Right.
sense. Scott, this is terrific information. Again, it's a very comprehensive bill. Thank you so much. This is Dr. David D. Schein for Business Law 101. If you've enjoyed this episode, please subscribe on your favorite platform.